Testing.
Testing. Testing.
One more time.
Testing.
I got you.
All right. Good afternoon, everyone. Sorry we're starting late. Today is October 15th, 2025. We're here for day 2 of the hearings in case number 9748, which is regarding BGE's application for a certificate of public convenience and necessity for the Brandon Shores Retirement Mitigation Project. Let's start by identifying who's here today. I know some folks weren't able to get here till afternoon, and happily it's afternoon. Let's just go ahead with appearances from BGE.
Good afternoon, Your Honor. Daniel Herson on behalf of the Baltimore Gas and Electric Company, and seated behind me is my colleague Joel Michelle.
Good afternoon, Brent Balea, also for BGE&E.
Good afternoon, Sari Amiel on behalf of Maryland Sierra Club.
Good afternoon, Your Honor. Sandra McLemore on behalf of the Power Plant Research Program.
Afternoon, Your Honor. Michael Sammartino for the Office of People's Counsel.
Good afternoon, Harrison Scher on behalf of the Commission's technical staff.
Good afternoon, Your Honor. Neil Bariti for the Zincs, Von Parasis, and Ms. Conover.
Good afternoon, everyone. Is there an attorney here from the Constellation Energy Generation LLC and Constellation New Energy LLC? All right. Do we have Lester Schott here today? The Rosalie Schott Living Trust? Jonathan Gunter?
Yes, ma'am, I'll present.
Mr. Gunter didn't approach the microphone, so it's not on the record, but he is present. David Button? Okay, Mr. Button is here. We have on the schedule today BGE witness Dopart, OPC witness Palermo, BGE rejoinder if necessary, and oral argument. Before we get started with those, do we have any preliminary matters that need to be addressed?
Yes, Your Honor. One preliminary matter for the Office of People's Counsel. Given your intention to finish the hearing today, Mr. Palermo changed his flight, and I'm wondering if he could appear first today rather than BGE's witness. And I've asked the company about this, and they expressed that was okay.
That works for me. No objection from BGE?
No objection. We arranged it ahead of time.
Okay, that works for me. PPRP, in Witness Rogers' supplemental direct testimony, she attaches PPRP data request 12-2, and it wasn't, there was no response at that time. And I don't think the response to PPRP 12-2 is in the record. I don't think it was attached to Witness Rogers' rebuttal or surrebuttal testimony. If I'm wrong about that, then correct me if I'm wrong, but if I'm not wrong about that, I want to enter that as a bench exhibit.
Okay.
So if someone could get me a copy of the response to PPRP 12-2.
We'll get it to your email
Yeah,
today.
that'd be great.
That's okay.
And copy all parties, please.
Okay.
BGE, is there any, or do you have any comments on the bench data requests and timing?
Yes, Your Honor, we can address those.
Do you mean the one that you just asked about, or the ones you asked about yesterday?
The ones from yesterday.
Oh, okay. Yeah, I think Mr. Herson's going to address number 1, if that was about the 10-year plan.
Number 2.
Okay, which
10-year
number?
plan's number 2.
Okay, 10-year plans.
There's a 10-year plan, and there's a,
Right. For the first one, which I think was for authority for our position about the scope of the jurisdiction of the commission, what we were thinking about that is would it be appropriate and acceptable to you if we were to provide that as part of our post-hearing brief?
so I think no, because there's obviously a page limit for post-hearing briefs.
Okay.
I think BGE could probably brief it separately and send that in 7 business days or 10 business days, if that's, and it can be styled as a bench DR.
Okay, that's fine with us. I'm just wondering, is there going to be an opportunity for reply briefs on that, or is this, in your view, a request from the bench to BGE to provide the information sought, not necessarily a second round of briefing?
I'd like it sooner. I'm not going to limit folks from including argument on that in the regular set of briefs. But I'd like it sooner, and that's an opportunity for it to be outside of briefs, outside of the brief limit.
Okay, that's fine.
Okay.
So 7 to 10, or what, 7 days from now, 10 days from now?
We'll do 7 business days. How's that?
That sounds good.
Okay. And on the other issue?
Yeah, Your Honor, I'll take that one on bench DR2. So yesterday, Your Honor asked us about the plan, capital P plan referenced in COMAR 2079-0401 as defined in 2079-0102. We're aware of that provision, but I will just be kind of in all candor, we were a little surprised to get the request from Your Honor. As we look at that provision, in all frankness, it's the kind of thing we would have expected to have gotten when we filed the application or when it got delegated to the PULJ. So as I sit here right now, we don't have a plan that I can pull off the shelf and provide to Your Honor, but I did go back and talk to our team about this last night, and we can pull something together, but they did caution me that there's probably going to be limited value to this plan, and let me just take a minute to explain why. This provision in COMAR is really a product of a different era. It's from the days of integrated resource planning, which we really don't do in Maryland anymore. I do realize that the commission mentioned the plan in an order a couple years ago and talked about the interest in getting these sorts of plans. I don't know if the current commission feels the same way as the prior commission that issued that order. There's only one commissioner excuse me, on the commission now that signed that order at the time. And I'm not aware of that request being made in other CPCNs since that time. Maybe I'm wrong about that. I didn't take a look.
I've agreed with you so far, but I think you may be wrong about that.
Okay. But anyway, what I was told was the concern is that there's a lot of moving parts right now to the energy industry situation in Maryland. It's a dynamic situation, really. You have questions about the state's energy policies, what they were a couple years ago versus what they may be going forward. You have open proceedings at FERC, or maybe better said, you have questions about how to interpret and implement certain orders from FERC, whether it's 1920 or 2222. You have changing processes and procedures at PJM, and also just sort of the situation in Maryland with the really unprecedented increase in load from electrification efforts as well as data centers coming into the state. I say all that because our folks are saying, yeah, we can give Your Honor a plan, but honestly, that plan may be stale, on day 2, just because there's a lot of changing dynamics. So I just wanted to bring that up because I don't know if that changes Your Honor's mind about whether you want that kind of plan or whether you think that's needed right now. If it doesn't change your mind, I'm told that we would need a little bit of time to put something like that together. So I was going to suggest that if Your Honor still needed it, that we could provide it at the same time we provided the reply briefs, which I think is November 24th. And I can answer any questions you might have.
Okay, so I want to be clear. I'm asking for the plan pursuant to COMAR. I'd like for it to be provided at the time of initial briefs. And then you may argue, and any party may argue in reply briefs that that it should be used or it shouldn't be used, that it's effective or it's not effective. All of the arguments that you just made, you can absolutely address them in your reply brief.
Okay. So that's November 7th then?
I'm not sure that I have that date in front of me.
Yes. Initial briefs must be filed no later than November 7th. Okay, we will commit to deliver that. Now, should that be just emailed to Your Honor and the parties?
I'd ask that it be filed in the docket.
Filed in the document, okay.
Yes.
Thank you.
I guess that's a good question for DR1 too. Do you want that filed in the docket or is that emailed to you and the parties?
DR1, yeah, please file that in the docket as well.
Okay.
And also, do you want our DR responses on the docket as well? I can go ahead and file it if you'd like.
The PPRP 12-2?
Right.
I don't know if that's confidential or not. That can just be returned to via email with a copy to all the parties.
Okay.
One more question for BGE. The confidential C attachment to the agreement between BGE, PPRP, and OPC. Did you talk to your client about that?
We did, and in the interest of sharing the love here, Mr. Michelle would like to address that particular issue, so I will.
Too many attorneys, too few judges.
Good morning, Your Honor. Joel Michelle, on behalf of BGE.
Good morning. You've been very busy this morning.
I have been. Your Honor, we certainly appreciate the opportunity to be heard on this issue again. We did, under your direction, go back and bring the issue to our client, and BGE is respectfully requesting that Your Honor maintain the confidentiality of Exhibit 2 to the August 29th agreement between PPRP, BGE, and OPC. And primarily there's three reasons for that. The first, my colleague, Mr. Belia, addressed yesterday, and I won't belabor the point, but just for the record, the basis there is that that document was produced based on confidential settlement negotiations.
Which are over.
Certainly, at this point, the settlement negotiations are over.
Okay.
But Your Honor has not issued a ruling whether or not BG would be granted a CPCN in this case at this point. And
But I'm not a party to that agreement.
understood, Your Honor.
Go ahead.
And we simply view that settlement discussion just as any other settlement discussion before state or federal court, where those discussions are held confidentially.
Okay.
But more importantly, Your Honor raised yesterday the comments filed by Senator Jennings, I believe. And although Your Honor mentioned that that was not the only basis for your leaning towards removing the confidentiality designation,
It's not.
understood. But for purposes of completing the record, I'd like to briefly address that concern by Senator Jennings. We can't speak for Senator Jennings, but we imagine that there might be some confusion about the nature of the study. And I think it's important to make clear that no party views this study as something that is needed to prove that this project is needed. It isn't a requirement of any statute, any regulation that BGE conduct this study. BGE filed its application in this case in July of 2024. The dispute about this study arose May 18th in PPRP's rebuttal testimony. And I only raise that fact to highlight the point that this isn't a study that is needed to fulfill any of the requirements that BGE has the burden of proving to receive a CPCN in this case. And I understand that there might be some confusion about that. The second reason that I think maintaining the confidentiality of the agreement, and particularly the attachment, is important is that not doing so would essentially undermine the agreement reached between the three parties. BGE had a right to cross-examine witnesses on this issue, whether or not Your Honor should require BGE as a condition to the CPCN to conduct the study. We, pursuant to the agreement, waived that right. We had the right to make argument in our briefing about this issue, and we have waived that right. And I believe that the commission, as well as state and federal rules of procedures, encourage parties to try to resolve issues like this, and we've done that. We've worked diligently with the other parties to do just that. And so it would be a bit unfair at this point for BGE, as well as the other parties, having waived certain rights that they otherwise would have had in this proceeding, to now be told that certain parts of the agreement are null and void.
I'm not touching the agreement. I'm touching the confidentiality of a document attached.
Yeah, understood, Your Honor, but pursuant to the terms of the agreement, all parties agreed that that attachment would remain confidential until Your Honor and the Commission issued a CPCN, or if Your Honor or the Commission issued a CPCN. And that is part and parcel to the agreement reached by all the parties.
Okay. And
And
the
it-
final argument?
Yeah, lastly, in terms of the concerns about the lack of transparency, and it ties to my first point. Again, this is not something, the study is not something that Your Honor is required to ensure BGE conducts in order to approve a CPCN. It is merely, BGE merely agreed to conduct the study because PPRP, OPC represented that they thought it would be useful and useful for the state, although we take a different approach on that, but primarily to resolve that issue between the parties. In terms of transparency, the details about the study contained in Exhibit C will be made public if and when Your Honor and the Commission issues a CPCN in this case. And frankly, if a CPCN is not granted, then the study is irrelevant. The primary purpose of the study is to assess any potential headroom that would result from the building of this project. And in fact, one of the assumptions of the study itself is that Brandon Shores, this project that BG has proposed, would be built. And so if we never get to the point where a CPCN is granted, BG's position would be that it's irrelevant, and therefore there is no transparency concern with keeping the exhibit and the details of that study confidential at this point.
Can you turn to confidential Exhibit C?
I'm there, Your Honor. Is there a particular page?
We are not in confidential session right now. So, and I have not said whether or not I think that this should remain confidential or not. So, without addressing any content of this agreement, can you, by using, first paragraph, first full paragraph, second full paragraph, there's no lines. Can you tell me what portion of this you believe is confidential or should stay confidential? I know you're going to say the whole thing, but I'm not hearing that.
I'm sorry, Your Honor. Are you saying that you don't understand?
Is paragraph one why should paragraph one stay confidential?
Your Honor, I think you're
No,
viewing.
I'm ignoring your second argument is what I'm doing, and I'm trying to I see in the agreement where it says in paragraph 8 the parties agree that the terms of the study agreement are confidential and should be treated as such in the CPCN. I see that. I want to know what about this merits that confidentiality. And so I want to know which paragraphs are important to be kept confidential.
Understood, Your Honor. And what I was going to say in response to that question is that there are obviously a number of different bases for considering a document to be confidential. One would be, for instance, if it contains CEII information or PII information. That is not our position, at least as I understand the contents of Exhibit C. The basis for the confidentiality, first and foremost, is that this document was produced as a result of a confidential settlement discussion, as is ordinary. That's the primary level. That's the lens through which we're viewing this document. And there hasn't been any final order in this case yet. So just as in any other litigation, the discussions, the settlement discussions, are maintained as confidential.
Okay, I'll issue a ruling on that later. Does anyone else want to be heard on it?
Your Honor, for the Office of People's Counsel, I'd just like to reiterate that we think the information resulting from this study would help us better understand the additional capabilities that this line would provide if it was constructed. And that information, while it's related to how the line will impact the transmission system as a whole, it's not required to determine whether the line is necessary to meet to address the reliability needs that PGM identified.
I understand.
So our OPC's position is, we agreed to defend the agreement. We think there's utility in the information that it would provide.
Okay, do you have attachment C in front of you?
Yes, Your Honor.
Did OPC's witness help make sure the language in the first half, the non-italic half of the second full paragraph, and 1A and B, did OPC's witness approve of that language?
OPC's witness reviewed the language, Your Honor.
And Judge Grace, also PPRP's witness was also reviewed it and was involved in developing it.
Okay, and I know that OPC doesn't keep witnesses in its office. That second to last sentence before the italics in paragraph 2, that begins with BGE.
Yes, Your Honor.
Will OPC have a witness available for that, what's contained in that sentence?
I don't know if I'm able to answer that question immediately, but I envision that we would.
Okay. And staff, has staff received this exhibit?
Yes, we have, Your Honor.
Okay. Okay. OPC, you can go ahead and call your witness.
Thank you, Your Honor. The Office of People's Counsel calls Mr. P. Jeffrey Palermo to the stand.
Appears to be transmission congestion here.
You might be able to. This is
Can you raise your right hand? Do you swear or affirm under penalties of perjury that the testimony you're about to give is the truth?
I do.
Can you state your full name?
It's P. Jeffrey Palermo.
Okay. And how are you employed?
I am engaged by the Office of People's Counsel.
Your witness?
Thank you, Your Honor. Mr. Palermo's direct testimony was submitted into evidence yesterday as OPC Exhibit 1. We do not have any direct examination for him. Mr. Palermo is available for cross.
Cross-examination from BGE.
No cross, Your Honor.
Sierra Club?
No cross, Your Honor.
Combined limited participants?
No cross, Your Honor.
Jonathan Gunter?
No cross, Your Honor.
David Button?
No cross, Your Honor.
PPRP?
No cross, Your Honor.
Staff?
No cross from staff.
I do have questions, I just have to find them. So you've been conducting power flow studies since 1976. In your direct at page 7, you talk about how proposed transmission system improvements from the project will impact BGE and PEPCO, including SMECO. And then on page 8, lines 2 through 4, is your conclusion. The planned transmission additions in BGE, PEPCO, SMECO area will allow a high enough level of imports that the area will not need added generation for many years based on PJM's current forecasted load. You ready for this? How many years?
I thought I had given an answer to that later on, and I can't say offhand. Give me a second. I thought that I think on page 22 that it could be able to serve load as much as 15,000 megawatts. Now, how long it takes to get to that is a separate question, and it all depends on what load forecast you want to look at and what data centers may come along. I'm not trying to hedge on the answer,
I
except that
understand.
I don't know.
Okay. When the statement says planned transmission additions. That statement on page 8, lines 2 through 4.
Which page again? Sorry.
Page 8, lines 2 through 4.
Okay.
That statement says planned transmission additions. Does that mean the planned transmission additions in this application only, or does that include all of the project listed in your table 1 on page 11, or all of those in table 1 plus all of those in table 2 on page 14? What does that statement refer to?
Table 1 and Table 2.
Table 1 and table 2.
So
Okay.
it is more than as I understand it, the project before this proceeding.
Okay. In table 1 on page 11, which of those RTEP designations have to do with this case?
To my knowledge, it's the 3780, the ones that are marked for BG&E, is my understanding. So,
Including the substation ones?
yes. My understanding is that the project includes the STATCOMs at Sully Road and Granite Substation as part of maintaining voltage in the event of contingencies.
Okay, so now generally for your power flow analysis, you made assumptions in order to decide how to conduct that analysis, correct?
Yes.
What were those assumptions?
The assumptions were the conditions forecast for 2028 in the RTEP 2022 Window 3 cases, and assumed the projects that were approved except for the MPRP, the Maryland Piedmont Reliability Project, that would connect the Dobbs substation with a substation in southern Pennsylvania at Otter Creek. Otherwise, everything else was assumed in service.
And you also took out Brandon Shores and Wagner, correct?
Correct.
Okay. Um, Counsel for OPC just stated that you've seen confidential Exhibit C to the agreement. Is that correct?
I believe so. I can't say no specifically what it was, but by the description, I believe that I've seen that, yes.
Counsel, do you have a copy for your witness?
I have a copy on my computer, Your Honor, but I didn't print out a copy for Mr. Palermo.
That would be wonderful. Thank you. My copy has notes all over it.
May I approach, Your Honor?
Sh-
Thank you.
I don't want to, for either you or me, to use any of the verbiage from that attachment when we're talking to each other right now. However, I want to ask you generally, is the description in that attachment sufficiently specific to be useful?
Yes.
Okay. Are there other assumptions that you would prefer to be reflected in that agreement? Don't tell me what they are, but
Yeah, I'm struggling with it because this is a partial approach to understand the conditions that we're trying to see, the headroom, and my hedging is only that. Sorry, I don't know what happened here.
you're fine. Take your time.
Okay, my only hedging is that PJM does a level of studies that are beyond the capability, I think, of even the BGE team. So this is a partial representation of the goal of determining the headroom. I'm not sure if I've answered your question now, but that's my only hesitation. I think that this is a fair representation and a fair methodology to obtain the headroom information that the parties were seeking.
Okay. In your testimony at page 23, there's a table 5.
Yes.
Can you can you explain those inputs? Explain each of those lines.
I can. I better. The idea here, this came to be because Southwest MAC is being charged by PJM for the inability to import enough capability. And that's related to the the transfer capability. So I was trying to estimate here how the transfer capability, the capacity emergency transfer limit, which is the term that PJM uses, would be affected by these changes. And so I assumed that an 80% dispatch of generation to make some reduction of that, and then looked at what the what the N-1 import limit would be, which is what is used for the capacity emergency transfer limit. And so that is what that second line is. So assuming a moderate amount of generation within Southwest MAC, that the maximum import would be 15,300 approximately. So that is all related to a reduced estimate of what the capacity emergency transfer limit would be, which is an N-1 test.
Okay,
Did that help?
yes. The forecast peak load, explain that, please.
That is the load that was forecasted for 2028 in the PJM RTEP, the case that we used.
And then the increased load that can be served, explain that line.
That's just the difference between the 15,300 and the 12,000.
Okay. I don't have any further questions. Do you have any redirect?
No redirect, Your Honor.
Thank you for your testimony this morning. You can be released.
Thank you.
Have a good flight.
Thank you.
OPC, I've seen paragraph 4. I assume OPC rests.
Yes, Your Honor.
Okay, OPC, I've seen paragraph 4 of the agreement between OPC, PPRP, and BGE. I want to get on the record what OPC's position is in this case. I'm okay, thank you. I carted down a bunch of notebooks and forgot my water today. Thank you, though.
So our position with respect to the issuance of a CPCN?
Yes. Yes.
So, Your Honor, we would, so as paragraph 4 states, we don't contest that there's a need for this project, given the reliability criteria issues that PJM has identified. But we would, the position that we would take in this case as to the grant of a CPCN, we would like to review all the evidence that's been submitted into the record, and then we'll state that position in our post-hearing filing.
Okay, thank you. Next on the agenda is BGE witness Dopart.
Yes, thank you, Your Honor. BGE calls Dr. Pamela Dopart to the stand.
Good afternoon.
Good
Can
afternoon.
you raise your right hand?
Yes.
Do you swear or affirm under penalties of perjury that the testimony you're about to give will be the truth?
I do.
Can you state your name for the record, please?
Pamela Dopart,
Can you spell your last name?
Dopart.
Thank you. BGE's witness?
So, Your Honor, the statutory parties have agreed to the stipulation and admission of Dr. Dopart's testimony, so at this point she's available for questioning.
Sierra Club?
No questions, Your Honor.
Combined limited participants?
I only have a few questions, Your Honor.
Go ahead. You can move that mic over if you want.
Ms. Dopart, as I understand your testimony, the strength of the electric fields and magnetic fields decrease with increasing distance from the source?
That's
right?
correct. That's that's a characteristic of electric and magnetic fields from all sources that produce them.
So the further the dwelling homes are from the source, the lines, the safer it is for the property owners?
It's not a measure of safety. It's simply a decreasing in electric and magnetic fields with distance. At a certain point in time, the levels of electric and magnetic fields from any given source will have diminished to the point of background and will be indistinguishable from any other source that may be producing those fields.
In your testimony, you state that the levels of EMF associated with the project at the edge of the right-of-way and beyond, both before and after the project, are far below the health-based exposure guidelines recommended by ICN, IRP, and ICES. You recall that testimony?
I do.
Okay. And so there is a benefit to be further away from the source of the electric and magnetic fields for individuals. Isn't that true?
It's true that the levels do decrease. In my testimony, I characterize the electric and magnetic field levels at the edge of the right-of-way because that is a common distance at which we tend to talk about and characterize EMF. However, the electric and magnetic fields for this project were calculated even for directly under the line where you would expect to see the highest levels, and even there, the magnetic field levels are well below those guidelines that I referenced in my report by ICNIRP and ICES.
Okay, so under the wires, they're below. At the edge of the right-of-way, they're even lower.
That's correct.
And so presumably, at the edge, there's even less of a health risk than under the wires.
Your Honor, can I jump in here for a second? So I've given Mr. Baruti a number of questions without objecting, but Your Honor's directive to Mr. Baruti and the parties over the weekend was that cross-examination was to be limited to their easement rights. These questions are not related to the limited participants' easement rights, so I just want to object on the
Response to that objection?
The 1931 deed specifically states that the electrical transmission line should be located in the center of the right-of-way, giving 75 feet distance from the edge of the right-of-way. And so if Ms. Dupart's testimony is that the further you are away from the source of the electromagnetic field, the less of a health risk you have. It seems to me, Your Honor, that the closer the lines are to the center, as required by the 1931 deed, supports our position that the deeds require that BGE keep their lines as close to the center of the right-of-way as possible. Not only pursuant to the deeds, but also it sounds like for the health and well-being of the property owners.
So you've made your point. The objection is sustained. And I think also the witness has studiously avoided saying that there's a reduced health risk the further you go away from the line. So objection sustained. Do you have any further questions?
No, Your Honor.
Jonathan Gunter?
No cross, Your Honor.
David Button?
So my only question is, you're saying that the electromagnetic fields stay within the right-of-way. They do not go outside the right-of-way.
The electric and magnetic fields from any source, including from the project we're speaking of now, but this would also be true of any of the electrical devices and appliances in our homes and offices, all the electrical wiring and lighting in our homes and buildings, decreases quickly with the distance. So directly under the lines, we would see the highest magnetic field levels that would decrease with distance. So at the edge of the right-of-way, you would expect the levels, and we have confirmed this with the calculations, the levels do decrease. They continue to decrease beyond the edges of the right-of-way. At a certain distance, and that will depend, of course, on various physical and electrical configurations of the line at any given time, the levels will have decreased to a point where they will be indistinguishable from the other sources that would then become closer to that person or that home, which would be the predominant sources of electric and magnetic fields in that area.
That got a little complicated for me, but basically you're saying that the electromagnetic fields from the tower wires do not go outside the right-of-way.
I'm not saying that. I'm saying the levels continue to decrease even as you go further from the right-of-way. You would potentially still, there would still be measurable levels of electric and magnetic fields, but they would continue to follow that property of decreasing as you moved even further away from that right-of-way.
Okay, you answered my question.
PPRP,
No questions, Your Honor.
Office of People's Counsel,
No cross, Your Honor.
staff.
No questions.
Ms. Dopart, you work for a company called Exponent. What kind of company is that?
Exponent is a scientific and engineering firm. There are about 1,000 employees around the world, a mix of engineers, scientists, physicists, health scientists like myself, epidemiologists, toxicologists. Many of our engineers are licensed. They're licensed PEs, and many of us in the health space have relevant certifications as well.
How often have you provided testimony for utilities?
I provide testimony for utilities perhaps a few times during the year, depending on the projects on which I'm working.
Have you provided testimony on EMF for anyone other than utilities?
I have not testimony. I've consulted and provided scientific information and guidance for other clients that wanted to know this information for their own questions.
On the subject of EMF?
Correct.
You indicated that you reviewed both PPRP's testimony on EMF and also the written public comment and oral public comment. Is that right?
That's correct.
Are there any other states in the United States that are issuing EMF standards?
There are a limited number of states that that do look at and address EMF in their public utilities process. There are 2 states that have magnetic field limits as part of their requirements to meet the application. The state of New York has a requirement that at the edge of the right-of-way, the magnetic field limits the magnetic field is limited to 200 milligauss or lower. And the state of Florida also has a requirement in their code. That limit for magnetic fields varies by the voltage of the line, but ranges from 150 to 250 milligauss, again, at the edge of the right-of-way. Both states have acknowledged that these are essentially status quo limits. So when they were codified, the states essentially looked to see what the existing magnetic field levels at the edge of the right-of-way were from their transmission lines already in existence within the state, and then said, going forward, new projects must not exceed the magnetic field limits that we're seeing currently. They're not limits that are necessarily based on any health, review of the health science, the health research. There's no specific health basis for these limits. But nevertheless, they are in the code, and so, utility companies in those states must meet them at the edge of the right of way.
Do you know when those New York and Florida limits were codified?
I would have to go back and check, but the state of New York just reissued so it was Article 7 of New York's code for public utilities. It's now, as of last year, they issued Article 8, so they updated it, and they did not change the magnetic field requirement when they did that.
You said that those were not based on health science. Are the Electric Power Research Institute and, the international standards that you've cited in your testimony, are those based on health science?
Yes, they are. And both agencies that issued those recommended exposure guidelines do discuss in their standard the research that they reviewed and why they came to the conclusions that they did. Both of those agencies conducted their own reviews of the health research on EMF and health effects, and also looked at the reviews conducted and published by a number of health and scientific agencies, including the World Health Organization and the International Agency for Research on Cancer.
Those are the two that you relied upon in your testimony?
In my testimony, the exposure guidelines, you mean, or the health agencies? Yeah, so those are internationally recognized exposure guidelines for electric and magnetic field exposure. They are considered protective of all known and established health effects of EMF, which occur at very high levels, much higher than those limits, and much higher than we are typically exposed to as we move throughout our day from any source, including transmission lines.
At page 7 of your rebuttal, you made predictions as to the changes in the magnetic field on the different segments proposed. Is that right? Can you summarize that?
Certainly. So, Exponent, under the direction of some of our licensed electrical engineers, use a model to calculate what the expected electric and magnetic fields from this project would be. The model that they use is one that was developed by the Bonneville Power Administration, BPA, which is an agency of the U.S. Department of Energy. It's been demonstrated in peer-reviewed scientific literature to be very representative of what actual EMF exposure levels are once a project has been built. For Exponent to run that model, we relied on a number of input parameters provided by BGE, information on the design of the line, the voltage, the loading, and from that we were able to calculate out what the electric and magnetic field levels from the project would be. We can also, and we did also, run these models for the existing line now so that we could provide some context between what is there now and what is calculated to be projected after the line is in operation, and that's what I discuss on page 7 of my testimony.
So for the Grayston to Maryland, PA segment, your testimony is that there would be a increase at the western ROW edge by 53 mgs and a decrease at the eastern right-of-way edge by 59 mgs?
Yes. So based on the changes to the project, and given that there will be two 500 kV lines that are going to be positioned closer to the western side of the right-of-way, we do see an increase in EMF levels on, and specifically magnetic field, as we're talking about here, magnetic field levels on that side, because as I discussed earlier, the electric and magnetic field levels do decrease very quickly with distance. So because the lines are being moved towards the western edge of the right-of-way, you do see a decrease in levels on the eastern edge of the right-of-way. However, at both edges of the right-of-way, and again, even directly, when standing directly under the line, these these magnetic field levels are still very well below the these exposure guidelines that we were discussing earlier from ICNIRP and ICES.
Okay, and the same is true, well, for the Grayston to Batavia segment. Magnetic field levels you calculated to increase by approximately 20 to 30 mgs at the western ROW edge, and at the eastern ROW edge, you calculated a decrease by up to 15 mgs.
Correct. So again, the increase there is due to the construction of the second double circuit 230 kV line that would be on the western side.
And is your testimony the same, that it's well below the standards?
That is correct, yes.
And how about the Batavia to Riverside segment?
Batavia to Riverside would be the same thing. The levels would still be well below the recommended guidelines for magnetic fields by both ICNIRP and ICES. The magnetic field levels aren't actually projected to change very much because there's not what's happening on that segment, as we understand it, is it's a reconfiguring of the existing circuit, and afterwards the loading on the line is expected to be less. In addition to distance, another factor that contributes to magnetic field levels is the loading at any given time on the line. So if there's less loading, you would see a decrease in magnetic fields. And so that's why there's a slight decrease noted there, but largely it's unchanged from what it is now.
You and some of the other BGE witnesses made suggestions in, I think, your rebuttal, to change PPRP's condition on EMF. Is that right?
Yes, I believe witness May for BGE recommended some changes, and I mentioned support for them as it related to EMF, yes.
Okay. And PPRP accepted those changes, is that right?
I don't actually know.
Okay. So, do you have the PPRP condition in front of you?
I do not currently.
Your Honor, these are the final conditions? Is that what you're
Yeah.
talking about? Okay.
It's PPRP Exhibit 19.
I have a copy. If I can give it-
That would be great. So we're looking at number 40.
Okay.
If you could go ahead and just read that silently to yourself, I'm going to ask you a question about it.
Sure. Okay.
Do you see that PPRP requires the measurements be taken at the center line and edge of the transmission line, ROW, while the transmission line is operating under typical loading conditions?
Yes, I do.
In your testimony, you talk about measurement of EMF at peak current flow. Which one of those is more appropriate?
So my testimony talked about and summarized both average and peak loading conditions. Average loading, which I think is fairly similar to what they're referring to here with typical loading, represents the loading you would expect on any typical average day out of the year. So it's a more accurate representation of what the loading would be throughout the year for most of the time. Peak loading acknowledges that, certain times of year for hours, maybe days at a time, depending, the load might be higher. And so we also do, for our exponent calculations, we do also look at peak loading to get an understanding of what it could be under those few hours or days.
So would you agree that to adequately assess what the levels are at the edge of the ROW, one should know both the peak day and the standard day?
I think it's most important to just know what the loading is when you're taking the measurements, and I think that's mentioned in here. There's some data that must be submitted with the measurement data, so that the measurements that were taken, you can provide adequate context. What was the loading at the time those measurements were taken, and how does it compare to other days throughout the year or other seasons?
Do you know what the range of measurements is currently?
The range of measurements on the line.
Yeah.
Now, I know what, based on the model that that exponent calculated, I have a general understanding of what the existing field levels are. Yes, although that is certainly different than taking measurements on any given day.
Did you see witness Rogers? I think it was her supplemental direct testimony where she talked about specific measurements that BGE had done as a result of other projects?
Yes, I do recall that.
And how do those, the results of those two BGE studies relate to the applicable standards?
I don't recall the specific values at this time, but I do recall noting that they were still well below the recommended exposure guidelines. And in fact, there have been a number of studies over the years by national health and safety organizations, and the U.S. National Institute for Environmental Health Sciences, for example, has published a booklet that includes, among other information on EMF, typical magnetic field levels from various voltage transmission lines. So there's just good data out there over the years for many different transmission line voltages and designs. And again, even standing directly under the line, magnetic field levels from transmission lines are generally still well below that 2,000 milligauss limit set by ICNIRP.
Okay, thank you. I don't have any further questions. Is there any redirect on behalf of BGE?
Just real briefly, Your Honor. Dr. Dopart, I believe at one point Judge Grace was asking you about limits that were set in other jurisdictions. Do you remember that?
Yes, I do.
conversation? Are those limits, well, what is the comparison between the limits or levels that you modeled or measured for the BGE proposed project versus the exposure guidelines in those other jurisdictions?
Certainly. So, as I was saying earlier, the two states that have set magnetic field limits at the edge of the right-of-way are New York and Florida, and those limits range from 150 to 250 milligauss, depending on the voltage of the line at the edge of the right-of-way. And based on exponents calculations for the proposed project at the edge of the right-of-way, the levels from this project are below the 150 milligauss limit and would therefore meet the requirements from both of those other states.
Okay, thanks. And then one other question. Judge Grace was asking you about your testimony experience. Do you recall that?
Yes, I do.
And I believe you said although you've testified for utilities, you also made presentations.
Yes, that's correct. I've made presentations on the topic of EMF at various scientific conferences, to other researchers and academia and government agencies, and I've published in this field as well.
And are those, is a listing of those, is that what is contained in Exhibit PD2 to your rebuttal testimony?
I believe if that's my CV, yes,
Okay.
that would be correct.
Thank you. That's all I had, Your Honor.
All right, thank you for your testimony. You
Thank
can
you.
be released. All right. Does BGE have rejoinder evidence?
Your Honor, are there any other witnesses that are presenting in this?
I don't believe so.
Okay. Do you mind if I take 1 minute to consult with my colleagues?
Sure, take your time.
Okay, thank you, Your Honor. So I've consulted with our team, and at this point, we are electing not to call any rejoinder witnesses, so we rest our case.
Okay, thank you.
Thank you.
All right. We're at the point of the hearing where we're going to take oral argument, and we're going to do it in the order that was previously sent to the parties. Although Baltimore Gas and Electric can elect to go last if it would like, since it's has the burden in the case.
Yeah, we would like to go last, Your Honor.
That's fine. So I'm going to go ahead and call all the folks who are on the list, even if you weren't here earlier. Constellation Energy Generation, LLC, and Constellation New Energy. Sierra Club.
Sierra Club is planning to file a post-hearing brief, but not participate in the oral argument, if that's
Sure.
okay. Thank you.
Hang on just a second. Mr. Gunter has a question, I think.
You were going to allow one of the interveners to enter exhibits because he was not available to be here yesterday. I was wondering if you're still going to be able to allow him to do that.
Yeah, absolutely. He can do that when he's called for oral argument. Are you talking about Mr. Button?
I am.
Yeah.
I just wanted to make sure that was not forgotten. Thank you.
Yeah, no problem. Thank you. Combined limited participants.
Thank you, Your Honor. And on behalf of my clients, the Von Paris's, the Zinks, and Ms. Conover, I want to thank you for allowing us to enter into this proceeding this late date to address the easement rights or lack of easement rights that we believe BG&E is allowed to exercise in their attempt to proceed with this project. You've made it clear that what you're seeking from us is focused only on BGE's claims regarding their easement interests, and so I will focus only on the easements or the deeds of right-of-way and the deeds of easement. The issue, for Your Honor, is what are BG&E's rights under the deeds of right-of-way and the deeds of easement. In order to determine their rights, Your Honor needs to interpret those documents. And there are certain rules of construction that we believe that you ought to exercise in order to interpret those documents. And the first rule of construction is the incorporation by reference doctrine. Maryland recognizes the incorporation of reference doctrine with regards to contracts and deeds. And the case I'll cite is the Whittington versus Mann case, and I'll be presenting a post-hearing brief with all the citations for these cases. The 1978 deed, and I'm going to ask Your Honor to focus on, I believe it's Mr. Sneed's affidavit, which is BG&E's exhibit number 6. Specifically, what Mr. Sneed titles easement documents related to John and Patricia Von Paris. And if Your Honor will turn to the deed dated January 18, 1979. You can see that the deed of easement and right-of-way makes numerous references to the pre-existing deed dated February 1, 19, I'm sorry, the 1979 deed for the Von Parises, as well as the 1978 deeds for the Zinks, all refer back to the 1932 deed, which grants, sorry, 1931 deed, which is the initial grant of the right-of-way from the owners of the property to Susquehanna Transmission Company. And so by virtue of the fact that the deeds that are at issue refer back to the 1931 deeds under the incorporation doctrine, means that Your Honor needs to interpret both deeds contemporaneously in order to understand the impact and intent of the parties with regard to the current deeds. The current deed cannot be read in isolation because it refers back to an earlier deed and an earlier plat. Current deed must be read in conjunction with that earlier deed and those earlier plats. In effect, both sets of deeds, both sets of plats must be read in conjunction with each other as a whole. giving meaning to all the terms that can be given meaning to. And if there is a term that is general as opposed to specific, then under rules of contract interpretation, the specific terms take precedent over the general term. The current deeds make reference to, quote, an easement and unrestricted right-of-way. The phrase or the term unrestricted right-of-way really cannot have any impact because the actual documents restrict the right-of-way. They specifically narrow what BGE can and can't do within that right-of-way. The easement has no reference to an unrestricted modifier. So, what are the rights under the two sets of deeds and the plats? The earlier deed, the 1931 deed, explicitly states that the purpose of the deed is for the erection and maintenance thereon of an electrical transmission line, singular line. And how do we interpret what it means to be an electrical transmission line? Well, it includes, according to the 1931 language, the towers, structures, wires, cables, attachments, appliances, and ground wires. That is the definition by the parties of what an electrical transmission line is. And the parties were very clear. They said it 4 times. The purpose of this deed is for the construction, patrol, repair, and maintenance work connected with said transmission line. And it continues. The grantee has the right to cut down, trim, and remove and keep out all trees and brush upon said right-of-way. And the right-of-way is clearly defined in the deed and plat as a 150-foot wide parcel of land with specific meets and bounds. And the grantee can maintain that right-of-way with regard to anything that might fall upon the said transmission line, again singular. The grantors reserve to themselves the right to use of the land in said right-of-way in any meaning which does not interfere with the said transmission line. So the parties say over and over again that the intent of this grant is for the construction and maintenance of a singular said transmission line. With regard to the right-of-way, the parties conclude no buildings or structures of any kind are to be erected on the right-of-way by the said grantors. The plat associated with the initial deed is even more specific. It actually depicts exactly where the parties intended this singular transmission line to be located. It's not to be located anywhere other than the center of the right-of-way. And so the utility easement being granted by the initial grantor is for a utility easement to be located in the center of a right-of-way. That plat is also referred to and incorporated by reference in the current sets of deeds. In fact, the current set of deeds, for example, the Von Paris deed refers to a plat, and that plat also specifically identifies the location of this singular transmission line. It identifies the boundaries of the right-of-way, and it explicitly identifies where the existing transmission line is located. And you can see in the more recent plat, that existing transmission line is, in fact, in the middle of, or in the center of the right-of-way. If there is any ambiguity as to whether BGE has the right to construct its utility easement anywhere other than the center of the right-of-way, that ambiguity should be construed not against the property owner, but against BGE, the utility company, the draftsman of the deeds and plats. I don't think there's any dispute who drafted these documents. It certainly wasn't the property owners. In interpreting and construing the terms of the deed, the plat, to determine what BGE's rights are with regard to their easement, courts also look to course of performance by the parties. We see the language explicitly stating that they're entitled to a singular transmission line in the center of the right-of-way. What did they do? What did Susquehanna do when they received this grant? They built a singular electrical transmission line directly along the center of the right-of-way. They performed consistent with the language in the deed. That is additional evidence of how the parties interpreted their own document. This is where we must build the utility easement along the center of the line, center of the boundary, and not deviate from that. And they didn't. As I understand it, BGE is now taking the position that they're entitled to build more than one line anywhere between the two edges of the right-of-way. That is inconsistent not only with the language of the deeds and the plats, but also the prior performance of the parties in interpreting their own documents. Based on their contention that as long as they stay within the 150 feet wide right-of-way, they have an unrestricted right to build as many transmission lines as they choose to, without regard to the property owners' rights, impact on their value of their property, or anything else. Well, that's an inconsistent interpretation of the documents, and we ask that Your Honor impose upon them the rules of construction that Maryland has recognized, which is incorporation by reference. You don't just look at the current deed, you look at the current deed that refers back to the original grant, which takes precedent. You look at both documents as a whole and you try and make sense of what it is that the parties intended. If there's a term like unrestricted right-of-way, and it creates an ambiguity or an inconsistency, and they're the ones who drafted it, the court should read the document consistent with all the terms, and all the terms include a very specific reference to a single transmission line. And so for that reason, Your Honor, I believe that BGE is intending to violate the terms of the easement, is intending to violate the terms of the right-of-way, and should not be permitted to rewrite the deed of easement and right-of-way. If they want to build a second line, they need to renegotiate a new easement. Until that occurs, they're stuck with the language that they agreed to and entered into with the property owners. I don't believe Your Honor can rewrite the deed. I don't believe BG&E can disregard the language of the deed. I believe the language is clear, unambiguous, singular transmission line along the center of the right-of-way.
Thank you. Lester Schott, the Rosalie Schott Living Trust, Jonathan Gunter.
Good afternoon, Your Honor. Thank you for allowing me to be a part of these proceedings. My first argument is that the deeds and all deeds for my property point to the easement for Gunter Exhibit 4, the original 1931 easement for my property. If you look at Gunter Exhibit 1, it references the plat book GRG number 14 folio 22. That plat, which is Gunter Exhibit 3, this exhibit is the plat for the Wildwood community, including the property of 1201 Wild Orchid Drive, my property. On this plat, it references SWC 221523, Gunter Exhibit 4. This reference is the first note on the middle of the page. Gunter Exhibit 4 is the easement recorded between William and Mary Robertson and Susquehanna Transmission Company, who originally got the easement, for a right-of-way of 150 feet. It references 4 times in the easement of "and the transmission line," singular. Not multiple, singular. As well as other language, including the encroachment in terms based on the agreement for location and width. As we heard from BGE witness yesterday, they admitted to have 2 transmission lines already in the row, with an increase to 4 transmission lines. This is quadruple what that 1931 easement allows. So they're already out of compliance with that 1931 easement. In Gunter Exhibit 1, the deed references the previous deed, 2003, in CGH 4673 folio 0222. Gunter Exhibit 6, marked 2003 deed. On this deed, it references the 1999 deed in CGH number 299 folio 62, Gunter Exhibit 6, deed 1999. The 2003 deed also references the plat in GRG number 14 folio 22, which is the Wildwood plat. On the 1999 deed, it references the 1998 deed in Liberal 2617 folio 857, Gunter Exhibit 6, marked 1998 deed. The 1998 deed also references the same plat as the others, GRG 14 folio 22, Gunter Exhibit 3. The 1998 deed references the 1981 deed, Liberal 1449 folio 531, Gunter Exhibit 6, marked 1981 deed. The 1998 deed also refers to the plat as the others. The reason to go back through all of these deeds is the 1981 deed. If you were to look at that deed, halfway down, marks, subject to the right-of-way agreement and easement approved the rear 75 feet of said property, and set forth, dated December 9, 1931, and recorded the aforementioned land in the Liberal SWC number 221 folio 523 from William Robinson and wife to Susquehanna. So every one of the deeds going all the way back to 1981, that is the first reference in the actual deed, reference the 1931. Have no mention of a 1981 deed. They all mention that 1931 deed, including the plat that is also on all of those deeds. My second argument is there's an easement from 1981, again, not easily found. My companies, any of these deeds never had them on them, but it was entered into record by BGE as Exhibit 6. In the 1981 easement, it brings in Schedule A on that easement agreement. It gives a more particular description of the location of the right-of-way. Instead, stated Schedule A is to be expressed made part hereof. On Schedule A, it references 1931 to easement, which is my Gunter Exhibit 4. So it helps with the location, and it references my 1931 easement. With that reference, it needs to incorporate the rest of that easement. It can't just say, I'm looking at just this one part. It must incorporate all language. And when there is a language difference between the 1981 and 1931 easement, the more specific language should be used, which is "and" singular line. The 1981 says unrestricted, meaning they can just do whatever they want to on my property in the row. The 1931 is very specific about what they are allowed to do in that row, and they have referenced it in that easement, and it then brings the rest of that easement into play. My last argument is, let's say BGE says the 1981 easement is the one we're supposed to use. This is the only one. The 1931 needs to be thrown in the trash. I don't believe that, but let's just say BGE does do that. I received a letter to move a encroachment on my property in July of 2010. The encroachment was a shed. I was paid $2,100 to remove that encroachment. In that letter, which is, I apologize, I went off piece for a second, which is my, in Gunter Exhibit 6, 2010 BGE letter, that letter references Liberal 221, Folio 523, which is the 1931 easement. If BGE is saying the 1981 easement is supposed to take paramount, why in their own communication to me, official communication that was signed by BGE, signed by myself, dated, going back to the 1931 easement? The 1981 easement does have language that deals with encroachment. If they felt that that was supposed to be the easement, why did they not mention that? So with me signing, getting paid to move an encroachment, that now makes my 1931 easement in paramount the one to look at. Because in July 2010, there was no other communication past that with BGE and myself, and everything else references that 1931 easement. So in finalization, from all the deeds that point to the reference of the 1931 easement, to everything being incorporated to the 1931 easement by the 1981, just by referencing that 1931 easement, to the communication, payment, and sending of payment with signatures from both BGE and myself in 2010 that references the 1931 easement, I believe BGE does not have any rights to build any further lines and are currently out of scope of easement because they currently, by witness statement, already have 2 in the row. Now they're asking to go to 3 and 4 transmission lines in the row to take their scope even further out of right-of-way. Thank you for your time, and have a great one.
Thank you. David Button. Mr. Button, you weren't here yesterday. We entered some exhibits into evidence. There's an exhibit from BGE 6, that purports to contain all of the easement documents that it obtained from the original source. Well, not from the original source, from I guess Baltimore County, all 3 of the counties. Is that right? Yeah, that's right. Do you have any documents that you want to introduce?
Yeah, I have a 2 deeds, 3 deeds, but one of them's for a gas line, and a land survey that I'd like to give to you.
Are those documents that you've circulated before?
No, may I bring them up, or how's this work?
Yeah, come and hand them to the court reporter. Do any of the parties want to take a look at the documents that were just handed to me? The alternative is I can scan them in, although one of them's very large. I think I can scan them in, and circulate them to all of the parties.
Yes, I'd like to take a look at that, Your Honor.
Okay. While you're doing that, folks, I'm paying attention to you. I got signed out of my email again, and I'm going to look at my phone for authentication. I am not ordering a pizza.
Fun stuff.
So we would, BGE objects to the introduction of all of those documents except for two, which were actually produced to us on Friday, October 10th, pursuant to your direction. And the two that were produced were the a right-of-way agreement. At the top it says R/W66201. It's a two-page document. The second document is a deed of easement and right-of-way made the 13th day of January 1981. So those two we would not object to, but the other documents you were provided, we do object to. We were not provided those in advance. We have no idea what, we have had no opportunity to review them, and so we do object.
How were those two documents provided to you?
The two documents I mentioned were, I believe, attached to Mr. Button's exhibit lists that were produced on October 10th via email to you and the parties.
So I think, I'm looking at that email now, and I think they were referenced in that. I think Mr. Button just sent a two-page exhibit list and didn't send any documents.
Well, I'll have to go back and look then. I think that's where we believe we got it, but we'll have to double check.
This is what I'm going to do. I'm going to go ahead and allow all four documents, and I will circulate them to the parties. You can then make argument based off of those. But this is a pro se litigant. I'm going to allow all four of these documents, and I think I'm just going to refer to them as Button Exhibit 1.
Okay, and just so I'm clear, what are the four documents? I know we have DB1 on his exhibit list. He has DB1, which is a 1981 deed, DB2, which is a 2008 right-of-way agreement. What are the other two that you're referring to?
So, okay, so I have DB, okay. We'll do it this way. DB1 is a 1981 deed of easement as designated in Mr. Button's email. DB2 is a 2008 right-of-way agreement identified in Mr. Button's email. DB3, which BGE objects to. It's actually several documents. Not identified in Mr. Button's email, I don't believe. It's a July 25th, 1931 deed. And I'll just say in associated documents. And DB4 is a survey. Trying to see if there's a date on this. Looks like 2014. Which BG objects to. All four are marked and admitted.
Okay, and Your Honor is going to scan those or somehow distribute those to the parties?
Yeah, I'm not sure how I'm gonna do this one. I'm gonna figure it out, but I'll send an email to all the parties.
And Your Honor, just to be clear, I think the way we found the first two, DB1 and DB2, were apparently they were filed previously with the commission somewhere, and we tracked it down, but they were not attached to his email on October 10th.
Yes, those are attached to Mr. Button's, October 3rd, 2025 filing under mail log number 322997, reconsideration. It's entitled Reconsideration of Petition to Intervene. It's docket item number 114. Okay, Mr. Button, we figured it out. You can go ahead.
So I'd just like for you to refer to the land plat there that shows the where BG&E's right of way is for the power lines. There's also one on there for a future gas line, but that's not there. If you can see that, you can see that the tower was right in the center of the right of way, and that's the way it was in the deed from 1931. And I just feel like BG&E, when they came out and moved the power lines a few years ago, they moved it out of that right of way and moved it over. At that point, they were out of their code because it's supposed to be in the center of the right of way. And they never contacted anybody about moving it, never got any kind of permits or talked to anybody about moving it. And the deed confines the use of a 150-foot corridor, does not authorize expansion beyond the corridor or construction of additional towers or higher voltage lines. The agreement further limits operations by prohibiting structures under or over the lines and by requiring minimum clearances. It's also important to note that the right-of-way on my property was granted for no compensation. That fact further limits the scope of BG&E's rights because under Maryland law, any uncompensated grant must be interrupted strictly and cannot be expanded without the owner's consent. Neither document conveys open-ended rights for the proposal upgrades. The commission, those properties have, the commission granted participation in similar situated landowners whose deeds trace back to the same 1931 corridor. Those properties have language nearly identical to mine. Consistent and equal treatment require that BG&E's rights on my property be measured against the same deed and spec limits. My residence sits less than 300 feet from the right-of-way. The proposed upgrades include increased structure height and voltage, would expand the physical and electromagnetic footprint beyond the recorded corridor. Any such expansion would impose a new and unauthorized burden on the servient estate, one not permitted under the easement documents. Under Section 7207, the Public Utility Commission may not issue a CPCN unless the applicant demonstrates legal rights for every affected parcel. In my case, the 81 and 2008 documents define a fixed corridor and limited purpose. They do not authorize the border construction footprint BGE now seeks. Respectfully, BGE has not demonstrated authority to exceed those limits. So, Your Honor, I respectfully urge the Commission to take a firm and fair position in this matter and keep all BG&E activity within its 150-foot right-of-way. The evidence before you shows that BG&E Gas and Electric has not established clear legal authority under the recorded easement document to undertake this purposed expansion. Under Maryland law, Section 7207, a certificate of public purposed expansion or convenience of the necessity cannot be issued without verified property rights for each parcel. Because that showing has not been made, I ask that the Commission deny the CPCN application as filed and require BG&E to negotiate fair updated easement terms with each affected property owner before any construction or upgrade proceeds. Because these easement on my property was granted for no compensation, any attempt to expand that use or impose new burdens without negotiations or payments would amount to an uncompensated taking of private property. Anything less would in fact authorize a physical occupation of private land that exceeds the rights granted in the recorded easements. Under the Fifth Amendment of the U.S. Constitution, Article 3, Section 40 of the Maryland Constitution, that would constitute a taking, one without due process or just compensation. My request is not an attempt to delay reliable service. It is an effort to ensure that the reliability is achieved in a way that lawful, equitable, and respectful of property rights. Upholding these principles will reaffirm the Commission's role as both protector of the public interest and guardian of the rule of law. Thank you, Your Honor.
Thank you. PPRP,
We waive oral arguments, Your Honor.
OPC,
OPC also waives oral argument, Your Honor.
staff,
Staff has no oral argument, plans to file a brief. Also, we'd like to add that we believe that all the criteria under PUA 7207 to grant a CPCN has been met.
thank you. BGE,
Thank you, Your Honor. Your Honor, on behalf of BGE, I wish to thank Your Honor for conducting these proceedings. I also wish to thank the parties, Commission staff, Office of People's Counsel, the Power Plant Research Program, the Sierra Club, Constellation Energy Generation, and the landowners present for their participation in these proceedings. The Brandon Shores Retirement Mitigation Project is critically important for keeping the lights on for all of BGE's customers in the region. The evidence in this case is overwhelming and demonstrates that granting a CPCN for the project is in the public's interest. Upon learning of the retirement of the Brandon Shores plant, the regional grid operator, PJM, studied the transmission system with that power plant hypothetically out of service. What they found was an unacceptable level of risk. Millions of customers could lose power. The reliability issues are so critical that the owner of the power plant, who wanted to deactivate it 4 months ago, cannot do so until this project is completed. Brandon Shores is being kept in operation by a special contract, and the name says it all: reliability must run. This RMR contract is costing customers millions of extra dollars per month for each and every month that it takes to permit and construct this project. And it means keeping a large coal-fired power plant with all of its attendant pollutants and greenhouse gas emissions operating in Maryland. PJM has directed BGE to complete this project by the end of 2028. Now, there's a lot of information in this case, but I want to make sure it's not lost that this project would be constructed within BGE's existing right-of-way. and that right-of-way has contained overhead transmission infrastructure for many decades. This is not greenfield development. The existing overhead transmission infrastructure has been a part of the local landscape for generations, and BGE's project has been designed to blend into what is already there. The project has been robustly and independently scrutinized by multiple state agencies for over a year, and not one disputes that this project is needed or that the Commission should grant a CPCN for the project. The Commission staff has recommended that the Commission approve a CPCN for the project. So has the Power Plant Research Program. And it doesn't stop there. Seven different state agencies have coordinated with PPRP to recommend approval. They are the Department of the Environment, the Department of Natural Resources, the Department of Commerce, the Department of Agriculture, the Department of Planning, including Maryland Historic Trust, the Department of Transportation, and the Maryland Energy Administration. These 7 agencies have evaluated this project from the perspective of their own jurisdictions, including the preservation of natural resources, public safety, history, culture, and recreational resources, and a wide range of other environmental and socioeconomic concerns. All have concluded that the project as proposed meets these requirements. And they have reached that conclusion after reviewing all of the information as provided, after conducting their own independent analysis and evaluations, and after reviewing BGE's responses to hundreds of additional questions and requests obtained through this year-long discovery process. The Commission staff and PPRP presented BGE with 20 pages of licensing conditions. BGE has agreed to every single one of them. At this point, there is a stipulation and agreement among BGE, PPRP, and OPC. That agreement and the licensing conditions attached thereto address a full spectrum of issues, including project need, environmental and socioeconomic impacts, capacity studies, EMF, and construction lines, and many, many more. In short, none of the statutory parties have contested the need for this project, and all of the parties have agreed that with the recommended conditions, the project adequately addresses any concerns. This agreement between the statutory parties is no small feat, and Your Honor and the Commission should give it considerable weight in determining the outcome of this matter. This is a very large, very complex, and very important project. The decision on whether to grant the request for a CPCN has huge ramifications. Indeed, millions of dollars in extra monthly payments to keep the Brandon Shores plant running and the possibility of power outages for millions of customers all hang in the balance. Knowing the gravity of this situation and the importance of adequate scrutiny, the parties took it upon themselves to conduct a thorough, thoughtful, and complete review of the project and concluded that, with the necessary licensing conditions, conditions that BGE has agreed to, the project should move forward. Local governing bodies have raised concerns regarding the need to minimize environmental and socioeconomic impacts on local communities. The evidence in this record is clear. There has, in fact, been a thorough analysis of a broad range of potential impacts, including EMF public health risks, impacts on property values, wildfires, view sheds, historic sites, air traffic safety, agriculture, parks, and traffic issues. Once again, the reviewing state agencies have concluded that a CPCN should be granted for the project. Local jurisdictions have also recommended that the Commission and BGE seriously consider undergrounding of the project and other potential alternatives. BGE listened and took a very hard look at undergrounding. But due to the cost, constructability issues, reliability issues, and maintenance issues, determined that it is not a viable alternative. BGE also seriously considered multiple other alternatives to the construction of an overhead transmission line and alternative routes. No other route or option was found to be superior or sufficient to address the needs at issue here. Property rights have also been given consideration. BGE understands and appreciates the concerns of the group of landowners who are challenging BGE's right to construct a certain portion of this project. BGE's position is that it has the necessary property rights to undertake the project, and a plain reading of the easement supports this position. All of the limited interveners are subject to the very same broad easement language, and that language is plain and unambiguous. It grants BGE an unrestricted right of way for the construction, reconstruction, operation, modification, and maintenance of gas and electric utility facilities upon, over, or under the land that is the subject of the easement. BGE's legal briefs will expand upon its legal arguments in this regard, but in sum, BGE's position is that this very broad, unambiguous language, when viewed from the perspective of a reasonable person, clearly provides BGE with the right to construct the additional circuits that are proposed as part of this project. There is no dispute and no party is challenging the simple fact that BGE has easements to access and construct infrastructure on each of the landowner's parcels. Rather, the dispute centers around the breadth of those and the access and construction rights, and those are property questions and disputes. Now, there has been a lot of conversation outside of these proceedings on the number of additional topics. Should Brandon Shores close? Why is it closing? Does Maryland have an energy policy? Did Maryland's energy policies contribute to the decision to close Brandon Shores? Was PJM right to say that this project is necessary? How did they reach that conclusion? And on and on and on. As important as these conversations are, the matter currently before your honor and the commission is much more straightforward. Given that PJM has directed BGE to do significant transmission system work, and given that BGE needs a certificate of public convenience and necessity prior to starting much of that work, does BGE meet all of the requirements necessary to obtain a CPCN, and is it in the public interest? BGE submits that the answer is a resounding yes. Through its application, its witnesses' testimony, and supporting exhibits, BGE has demonstrated that it has met the necessary requirements for a CPCN under Maryland law, and that it is in the public interest to grant a CPCN for this project. In closing, BGE respectfully requests that your honor and the commission grant BGE a CPCN for the Brandon Shores Reliability Mitigation Project. The project has been designed to minimize environmental and socioeconomic impacts, and it is necessary to ensure the reliability of the transmission system. Finally, timely review and approval is critical so that Maryland utility customers will not have to bear the cost of millions of dollars in additional RMR payments to keep the Brandon Shores power plant running. Thank you for your time and consideration of this important matter.
All right, that concludes oral argument. Next up is briefs. There was a notice of briefing schedule issued on October the 6th, and that requires initial briefs on November 7th, 2025, reply briefs on November 24th, 2025. Does any party want to make a motion as to the length of the brief?
For staff, just noting that the commission's regulations have that at 50 pages.
Yes.
Your Honor, we'd propose that the limit be 75 pages, just given to the volume of information in this case that at least the applicant needs to address, so that's would be our proposal.
Any objection? Okay, there will be a 75-page limit for briefs in this case. Thank you, Mr. Dean. I have received from PPRP BGE's responses to PPRP data request 12-2, and so all the parties should have received that as well in email. With that, are there any other matters that need to be heard before we finish for the day?
No, Your Honor, we just want to thank you on behalf of the company for conducting these proceedings in a timely and orderly fashion. We really appreciate it.
Thank you. All right, we are finished for today. Thank you, everyone, for all of your efforts. We can go off the record.
Well, thank you, Your Honor.